Hi, welcome to the breakdown. Welcome to All Rise News. Please welcome Adam Klasfeld. We have some pretty major breaking news this morning. You and I have been discussing, obviously, this case for a really long time. And sort of the crux of this entire incarceration, which now has been ruled unlawful by Judge Sinis, was that there was no existing removal order on the books going back to October 10th, 2019, when a judge said, you cannot remove him to El Salvador, but did not explicitly put a removal order on the books. And since that time, there has not been an explicit removal order, which means you cannot incarcerate him because under the rules and under some Supreme Court precedent, Zendvitis, I think is the name of the case. I may be pronouncing that incorrectly. They put a 6-month cap on it. For how long you can incarcerate somebody. But that is pending assumed removal for a non-citizen from this country. And Judge Sinis, in her ruling this morning, which releases Abrego from custody, said that case is instructive. It doesn't quite fit because here we don't even have a removal order. So joining me to talk about this order, this historic order releasing Mr. Abrego, which has to be hugely embarrassing for folks like Kristi Noem and Tom Homan and Donald Trump and Stephen Miller, who have said over and over again, he will never walk free in the United States. Today, he walks free in the United States. Please welcome Adam Klasfeld from All Rise News. Adam, it's very early here on the West Coast, but I've had a moment to skim through. I've only had this much coffee, so I'm working on my brain is starting to get going this morning. But let's talk about this really important ruling today from Judge Sinis.
Absolutely. A 31-page ruling. And you mentioned it, but the line ringing in my ear as you were talking was Kristi Noem standing in Congress and testifying and saying that Kilmar Abrego Garcia would never, ever step foot on U.S. soil. Now he's been ordered released again by a judge. The first time he was ordered released on bail by 2 judges in his criminal case. I would say even before that, he had the Supreme Court ordered the facilitation of his release from a terrorism prison in El Salvador, Sicotte, and judges and courts all the way up to the Supreme Court have been saying again and again and again, you have to follow the law, you have to follow the procedures. And this was a long time coming. I think that we spoke last month when I was down in a federal court watching Sinis read the Government the Riot Act on this issue in Greenbelt, Maryland. I'm going to read some of the ruling. I actually have it printed out. It's a 31-page decision. It is quietly blistering. It says at the introduction, since Abrego Garcia's return from wrongful detention in El Salvador, he has been redetained again without lawful authority. For this reason, the court will grant Abrego Garcia's petition for immediate release from U.S. custody. Goes on to say that the history of Abrego Garcia's case is as well known as it is extraordinary, and repeats some of all that we know. How it all started in March with the Trump administration hustling him onto a plane without any due process, along with hundreds of other immigrants, to El Salvador, where a court order had barred his removal. He had spent time in that prison, tortured, that notorious prison, which Sinis in a prior ruling described as one of the most dangerous prisons in the Western Hemisphere, that prison. And after he was ordered released by the Supreme Court and 5 separate court orders, taken back to the United States, not to be reunited with his family, but to be prosecuted on smuggling charges. And once he had won the right for a release from pretrial detention, instead of letting him await trial at his Maryland home with his family, they had him surrender to immigration detention after the weekend. He had a few days of release, and proving Kristi Noem wrong in those few days that, yes, he is stepping foot on U.S. soil. But since that time, surrendered to Immigration and Customs Enforcement's field office in Baltimore. And ever since then, the government has been coming up with a variety of different places on the global map where they want to drop him. First, it was Uganda. Then it was Ghana. Then it was, Eswatini. Then Ghana. Then Liberia. And all of that, the first three countries that they tried to send him to said that they did not agree and they were not consulted in embarrassing public statements. The fourth country, Liberia, the government had claimed that Costa Rica withdrew its agreement to accept Abrego Garcia, where Abrego Garcia agreed to self-deport, said, the government is clearly, they're not waiting till I get to defend myself at trial. I will go to Costa Rica where my human rights will be respected. And in this ruling, I want to point out, Zinis said that the government, quote, affirmatively misled the tribunal by claiming that Costa Rica was no longer on the table.
Yeah, and I wanted to bring that up because I thought that was pretty stunning mention from Judge Zinis because of the Saturday or Friday night, late Friday night Washington Post article we got, which she cites twice in this ruling, twice that I saw, that said, "Hi, Costa Rica here. We never closed the door. He was always welcome here." And I think Judge Zinis actually points out that she believes that, or she has ruled that the government misled on this because they filed that with that particular briefing under seal. And she pointed out, which is odd, because all of the other countries for third country removal were not filed under seal. And so I thought that was interesting that she pointed that out. But a lot of it has to do with the fact that once that became public and Costa Rica got a hold of it, Costa Rica decided to weigh in and completely trashed this memo, this declaration that the sixth witness wrote, that he came in and answered questions and admitted that the State Department wrote some of it for him, and he didn't even understand what it said.
Right. And let's put this into even further perspective. I watched this unfold when this was playing out in courtrooms in Nashville and in Greenbelt. And what happened was Kilmar Abrego Garcia fought for, across multiple hearings, his release from pretrial detention. And toward the end of that, after he won, and the government was about to see him show the lie to the notion that he would never step foot on U.S. soil again, they tried to put a plea deal on the table, say, plead guilty, ratify these charges, and when you're done, you get to go to Costa Rica rather than El Salvador, where you fear persecution and will be tortured. We'll grant you safe passage if you plead guilty to these charges, salvage our case, and essentially
help us not look like assholes is basically what it is.
And serve a small sentence, send you to Costa Rica. Well, he rejected the plea offer, was released, reunited with his family, and then all of a sudden, they can no longer send him to Costa Rica. Now, all of a sudden, they can only send him to human rights abusing countries halfway across the world where he's never been. All of a sudden, they can only send him to Uganda or Eswatini, the last absolute monarchy on the African continent, or Ghana or Liberia. And they say presumably with a straight face, because it was a written filing, that Liberia is a wonderfully human rights respecting country in contravention to what their own State Department says about their respect for human rights. And they say that Costa Rica's off the table until Washington Post exposes that as a lie, as you mentioned. But this all began, the whole talk about Costa Rica began with plea discussions, a plea deal that Abrego rejected, and in favor of his release and fighting the charges at trial. And all of a sudden, the government took that off the table, which, is lawyers argue, is further proof of vindictiveness. So that vindictive prosecution filing is still live. We will see though the hearing on vindictive prosecution is perpetually delayed, what will happen to his criminal case, whether his criminal case will even survive. But this is victory after victory after victory by a powerless and vilified immigrant man with a family in Maryland against the weight and force of Trump 2.0 and the apparatus of government that, rather than have him defend serious allegations at trial, continues to do so in the public sphere, and goes behind the scenes to avert a need for a trial by sending him to far-flung locales on the African continent where he's never been, where he doesn't speak the language. So it's a major victory for Kilmar Abrego Garcia if the government respects it. This remains to be seen, but the order is for the immediate release, and immediate means immediate in the terms of this order.
Yeah, and all the government had to do was what Arrest Reveni advised them to do, which was to return Mr. Abrego to the United States and then put him back in the immigration system, possibly get an order of removal, a proper order of removal to any other country besides El Salvador, or along if they didn't do that along this entire journey, just remove him to Costa Rica as originally agreed. Adam, I looked for and didn't see, but I did a cursory skim of this pretty long order. Anything about that threat to plead guilty to the two charges to be allowed to go to Costa Rica? I didn't see it. I'm wondering if it's not really necessary for Judge Sinis to bring up in this particular case. Maybe that's more of a vindictive and selective prosecution in his criminal case, but I noticed she did not bring that up, and I thought she might, but did I miss it?
I didn't see it either. It's possible that I missed it. This is very breaking news. It's a 31-page order with extensive footnotes. I would say that you are correct that this is the plea deal discussions are something that would be more properly brought in the Middle District of Tennessee, where where that is being considered as evidence of vindictive prosecution. But yeah, it's a powerful point, and it's one thing that I suspect we're going to hear a lot in the near future from DHS, from Trump 2.0, is this idea that the courts won't let us remove this dangerous criminal. And that's going to be the rhetoric. But I wanted to emphasize that's the whole point of this whole Costa Rica thing, is that if the government wanted to deport Kilmar Abrego Garcia, they had an option. Costa Rica. Costa Rica accepted Kilmar Abrego Garcia, who has agreed and affirmatively through his lawyers in court in 2 consecutive hearings. Judge Sinis, before issuing this ruling, asked his lawyers repeatedly, is it still your position that if the government is willing to facilitate the deportation of Kilmar Abrego Garcia to Costa Rica, that you're ready to do it and that you won't oppose it in any way? And both times they said yes. So this isn't about the government trying to deport a purportedly dangerous criminal, or whatever they level at him without letting him defend himself at a trial. This is about the government trying to send him to a far-flung country where he might be redeported to the place where a U.S. court order blocks his deportation for fear of persecution. That is the level of what we're dealing with here. It's not, if the government, and to repeat it again, if the government wanted to deport Kilmar Abrego Garcia, it could. If they wanted to try Kilmar Abrego Garcia with the allegations that they charged him with, or the allegations that they didn't charge him with, they could charge him. They can let him defend himself like any other person, citizen or non-citizen, that our Constitution affords right to defense, a right to confront one's accusers. They have not shown a willingness to do that. And this ever since this entire episode started in March.
Yeah, and they've been avoiding U.S. courts for this reason. That's why they've tried to avoid the discovery in the contempt proceedings with Judge Sinis over Abrego by arresting him and bringing him back and ending, like bringing him back and ending trying to end the discovery into why they refused to return him to the United States in the first place, because they were trying to hide that agreement with Bukele that we would drop the charges against MS-13 actual drug traffickers and send them back to Bukele so that he could, probably hush them up because they made a deal in order to get Bukele in office. Also, this new news that we're hearing from the Pentagon, where they wanted to at first put U.S. The Venezuelan or Caribbean boat strike survivors in Seacoast prison after that September 2nd double tap that we're all investigating, and that the consideration was that they wanted to decide eventually to remove them to their countries of origin because they wanted to keep them out of the U.S. court system, because they didn't want the courts to know. They didn't want to have the scrutiny of the courts. And this is why they filed the Costa Rica declaration. Costa Rica won't take him under seal to hide that lie from the public, because they knew if it came out, Costa Rica would say, no, he's welcome here. And so I think that's why Judge Sinis said that it was deliberate, them trying to hide what they were saying about Costa Rica over and over and over again, is to avoid the scrutiny of due process.
Right. And we often talk about how Seacoast is in the words of Judge Sinis, one of the most dangerous prisons in the Western Hemisphere. And there's torture there. The more fundamental problem of sending people without due process to prison is that you're sending people without due process to a foreign prison. And it's something that we've become desensitized to, in a sense, in Trump 2.0, that it's something that has just become a thing that happens in March, that we do not have a hearing. You are on a plane to a country that you have never been to, in the case of hundreds of the Venezuelan immigrants who were sent there on March 15th. And that this is now, to your point, sending people to prison because they survived a boat strike, that the public hasn't been entitled to see the evidence as for the reason why there has been shooting down of boats that look too small to be involved in the crimes that they're accused of. The things that have become absolutely normalized is absolutely shocking.
Yeah, and we're going to hear testimony from whistleblower Erez Ruveni next week in Judge Boasberg's contempt proceedings. This is the original Alien Enemies Act case that put Mr. Abrego on those planes bound for El Salvador. So we're going to hear testimony from him and Drew Ensign next week. So it'll be interesting to see if any of the Abrego issues come up during that testimony too. I'm certain they might. But I also wanted to ask about, Judge Sinis mentions multiple times that the government, during this whole litany of litigation for Mr. Abrego, has defied her court orders. And she mentioned that the government intentionally misled on Costa Rica, especially after that Washington Post report came out. And with regard to the memo that Costa Rica wasn't taking anybody anymore from that guy named Cantu, she says in a footnote, one second, Cantu is the sixth witness whom the court directed respondents to prepare for either deposition or in-court testimony concerning this case. Each witness was either unprepared or defiant in their refusal to answer questions. This court will consider the entire course of conduct when it reaches the motions pending in Abrego 1. Can you talk about that sentence? Is that some sort of contempt, or what's Abrego 1? Tell us the difference between Abrego 1 and this proceeding, and what she means when she said that the court will consider all of this contempt, basically, when it reaches the motions pending in Abrego 1.
Right. Abrego 1 is the reason why Abrego is not still in Seacoast. Abrego 1 is the habeas corpus case, the first habeas corpus case.
Oh, when she originally tried to elicit contempt proceedings.
Exactly. And so there is I've described it before as the Chekhov's gun in all of this. That is will there be a price for, in her words, misleading the tribunal? There is the question of sanctions and all this that hasn't been addressed. And throughout this process, she's been very deliberate. She's been cautious. She's very aware of Trump 2.0 DOJ litigation posture, which is challenge everything. And she made a remark during the last hearing that was the first time I heard this expression, but I think it really describes her, the way that she judges, which is eat the elephant one bite at a time. And that's been how she's done this. Nothing has been quick, nothing has been rash. This ruling was preceded by 3 or 4 evidentiary hearings where she ordered the testimony of an official with knowledge. They kept putting on government officials with no knowledge of the topic that that she had demanded answers about. And so I think that this Chekhovian gun, as it were, could fire. There could be sanctions imposed. I think that she, if I'm not mistaken, chose the path of considering civil sanctions, so it might not pan out in the sort of Boasberg fashion that we've seen in the Washington, D.C., where everything is challenged it brings its own appellate challenges. When you try to bring criminal contempt, and of course, referring criminal contempt to Trump's DOJ is a non-starter, and you have to consider enforcing criminal contempt through a privately appointed prosecutor by the court, and
which the Supreme Court will probably say no to.
Right. Well, it has its own complicated history as well. So we'll see. I think that could be the next shoe to drop.
Yeah, so eat the elephant one bite at a time. This bite specifically was to address his incarceration, his unlawful incarceration under INA, under Zendvitis, under Supreme Court precedent. One notable thing I wanted to mention before we get out of here, she says in a footnote that this opinion will use the term non-citizen as equivalent to the statutory term alien, in keeping with recent preferred nomenclature. And she quotes Justice Kavanaugh to use that language instead. And I thought that, to take a moment to point that out, because a lot of these filings that we read, that you and I go through, criminal alien, alien this, illegal alien that, because statutorily speaking, non-citizens are referred to as aliens. However, from a Kavanaugh concurring opinion in 2020, this opinion uses the term non-citizen as equivalent to the statutory term alien, citing 8 U.S. Code 1101A3 from Justice Kavanaugh. Right. Good old Kavanaugh, stop Kavanaugh. Right. That's what I thought that was just a nice little, I'm going to do what Justice Kavanaugh does, and I'm not going to refer to him as an alien. I'm going to refer to him as a non-citizen for purposes of this ruling.
Right, and it goes to show that in dealing with the law and grappling with statutes, you don't need to engage in dehumanization. So it's those little things that change society and change a way of thinking.
Yeah, exactly like why we refer to him as Mr. Abrego as opposed to Abrego Garcia, because that was his wish. Well, thank you very much. Is there anything else that stands out to you in this order that you wanted to cover today? Does it say when he will be released? Is it immediate? Is it when can we expect he will be out of jail? And will the government respond by trying to get an immigration judge to issue an order of removal for him? Will they concede and send him to Costa Rica, or will they embarrass themselves at a potential trial if that's not dismissed, if the charges aren't dismissed for vindictive and selective, which the Judge Crenshaw there has decided already that there's probable cause to believe that there was vindictiveness in his prosecution. But they are moving forward little by little with a couple of things under seal on that docket. What do you see maybe are the next steps for the government here now that they've been thoroughly embarrassed, although they are shameless and probably
Mhm.
don't care?
I will be watching to see if he's immediately released. I'm sure that maybe even during the course of our discussion, there may have been docket activity. There could be challenges, but there is a court order and it has the word immediate. I am reaching out to counsel and spokespeople for Mr. Abrego. And as soon as I have any information on that front, I'll be sure to report it, and I'm sure we'll be chatting about it again soon.
Yeah, and I saw something was entered on the criminal docket last night as well. And once we go through that, maybe we can jump on another live and see where we go from there. But we'll continue to follow this case. Everybody, if you have the means and the ability, please support All Rise News, support Adam Klasfeld. It's your financial support, although it's not required to read his updates. It's totally voluntary, but it helps him travel and go to these hearings and jump on live conversations like this so that we can all stay informed. So if you have the means this holiday season, please financially support All Rise News, because as I always say, we don't have, as independent media, as independent journalists, we don't have corporate overlords funding our travel and funding our lodging. So any little bit helps, and we really appreciate it. And because the reporting that comes from Adam Klasfeld and All Rise News is indispensable reporting. So thank you very much for joining me today. Any final thoughts before we get out of here?
Well, I will say that the great work that you do too, Allison, is definitely deserves and requires support. So I would throw that right back to you, folks. If you are a subscriber to All Rise News, consider joining the breakdown as well. And just a kind of scheduling note. Next week, I will be in Milwaukee, Wisconsin, all of the week to cover the trial of Hannah Dugan. So look out for that. I'm sure that we're going to talk more about that in the future as well.
Yeah, we'll have to have you on Cleanup on Aisle 45. And your contributions, by the way, everybody listening, thank you so much. It allowed me to file for example, my FOIA request with national security law to get the Epstein training videos. Adam, we have to talk about this on another time, but you'll never guess what the government's argument is to not hand over or not to do expedited processing on the Epstein videos. Their actual argument in the latest filing, and I'll go over this on the Midas Touch Network this Sunday,
I,
their actual argument is that there is not widespread public uh, interest in the Epstein case.
Okay. I haven't had that good a laugh, Allison. And so to that point, it's we talk a lot about independent media having to take go into the spaces to get the documents to fight them in court, and the support of independent media to fill those spaces in an age of media consolidation, when where the well-heeled newsrooms that get the money to send people to the courts, to send lawyers to get the documents, that's the promise of independent media. One of the reasons we work so well together, Allison, is we understand the importance of really investing in news and in news gathering. So I'll end on that. And thank you for that good laugh about how there isn't really that much interest in Epstein or the circumstances of his demise.
Yeah, there's just no widespread public interest in it. And by the way, I've just written that up at MuellerSheWrote.com on the breakdown. You can read what the government said. They did concede, though, that I'm a real media outlet, so that's nice to hear. But yeah, you can read their argument at the breakdown at MuellerSheWrote.com. I typed it up. I included a link. Nobody's really covering this because it's kind of small potatoes compared to all the other news that's going on. And there's no widespread public interest in the Epstein case. So if you want to read that argument, if you want to read that twisted, ridiculous argument, it is on my Substack right now. So thank you so much, everybody, for being here, for taking an interest in these cases. Knowledge is power. We appreciate you, and we'll see you next time.
See you next time.